How do you protect your business, define roles, and ensure everyone's on the same page from day one? If you've ever asked yourself that, you're in the right place. We're diving deep into employment agreements today, and more specifically, how Rocket Lawyer can make crafting these crucial documents an absolute breeze. Stick around, because by the end of this video, you'll not only understand the ins and outs of employment agreements, but also how to leverage a powerful tool to secure your business's future. Why employment agreements are your business's best friend. Let's face it, nobody likes paperwork, but some paperwork is simply non-negotiable. An employment agreement is one of those things. Think of it as the blueprint for the relationship between your business and your employees. It's not just a formality. It's a vital legal document that sets expectations, clarifies responsibilities, and most importantly, protects both parties. Imagine you hire a new marketing genius. They're full of ideas, energy, and a promise to skyrocket your sales. Without an employment agreement, what happens if they suddenly decide to take all those brilliant strategies to your competitor? Or what if there's a disagreement about their compensation or working hours? These are the kinds of headaches an employment agreement prevents. At its core, an employment agreement outlines the terms and conditions of employment. This includes everything from job duties and compensation to confidentiality clauses and intellectual property rights. By having everything in writing, you minimize misunderstandings, reduce the likelihood of disputes, and create a clear, legally binding framework for your working relationship. It's about setting boundaries and expectations up front, which fosters trust and professionalism. Key elements every employment agreement needs. So, what exactly goes into a robust employment agreement? While each agreement will be tailored to specific roles and businesses, certain core components are universal. 1. Identification of parties. This might seem obvious, but clearly stating who the employer, your company, and the employee are, including full legal names and addresses, is the foundation. 2. Position and duties. This section defines the job title and a clear, concise description of the responsibilities and duties the employee is expected to perform. Be specific here to avoid ambiguity. For example, instead of manage marketing, specify, develop and execute digital marketing campaigns, oversee social media strategy, and analyze campaign performance. 3. Compensation. This is where you lay out the salary or hourly wage, how often the employee will be paid, and any bonus structures, commissions, or other forms of remuneration. Don't forget to include details about overtime pay, if applicable, and any deductions that might be made. 4. Term of employment. Will the employment be for a definite period, e.g., a one-year contract, or will it be at-will employment? At-will employment means either party can terminate the relationship at any time, with or without cause, provided it's not discriminatory. If it's a fixed term, specify the start and end dates. 5. Work schedule and hours. Define the expected working days and hours, including any provisions for remote work, flexible schedules, or required overtime. 6. Benefits. This covers any employee benefits your company offers, such as health insurance, retirement plans, like 401k, paid time off, vacation, sick leave, holidays, and other perks. Clearly state eligibility requirements and how these benefits are administered. 7. Confidentiality and non-disclosure. This is a huge one. Most businesses have proprietary information, trade secrets, customer lists, marketing strategies, financial data, that you wouldn't want falling into the wrong hands. A robust confidentiality clause prevents employees from disclosing this sensitive information during and after their employment. A non-disclosure agreement, NDA, is often embedded within this section. 8. Intellectual property, IP, rights. If your employees will be creating anything for your business, software, designs, marketing materials, content, an IP clause is essential. This clause typically states that any intellectual property created by the employee within the scope of their employment belongs to the company. This protects your creative assets and ensures you retain ownership. 9. Non-compete and non-solicitation clauses. Use with caution. These clauses can be powerful but are also subject to varying legal interpretations and restrictions depending on your jurisdiction. Asterisk, a non-compete clause restricts an employee from working for a competitor or starting a competing business for a specified period after leaving your company. Asterisk, a non-solicitation clause prevents an employee from poaching your clients or other employees after they leave. It's crucial to understand that these clauses must be reasonable in scope, duration, and geographic area to be enforceable. Many states have strict laws governing their validity. Always consult legal counsel regarding these clauses. 10. Termination. This section outlines the conditions under which the employment relationship can be terminated by either party. This includes circumstances for termination with cause, e.g., misconduct, poor performance, and without cause, as well as notice periods required and any severance pay provisions. 11. Dispute resolution. How will disputes be handled? This section might specify arbitration or mediation as a preferred method over litigation, which can save time and money. 12. Governing law. This clause specifies which state's laws will govern the agreement, which is particularly important for businesses operating across different states or with remote employees. The challenges of crafting employment agreements from scratch. Now you might be thinking, that's a lot of legal jargon and specific details. And you'd be right. Crafting a legally sound and comprehensive employment agreement from scratch can be incredibly challenging, even for seasoned business owners. Here's why it's so tough. Legal complexity. Employment law is a vast and ever-evolving field. Laws vary significantly by state and even by city. What's legal in one place might not be in another. Getting it wrong can lead to serious legal repercussions, including lawsuits, fines, and reputational damage. Time-consuming, researching all the necessary clauses, drafting the language, and ensuring compliance with all applicable laws takes an immense amount of time. Time that most business owners simply don't have. Risk of omission. It's easy to overlook crucial clauses or important legal protections when you're not an expert. A small omission could leave your business vulnerable down the line. Costly legal fees. Hiring an attorney to draft every single employment agreement can quickly become very expensive, especially if you're hiring frequently. Lack of customization. Generic templates found online often aren't sufficient. They lack the ability to be customized to your specific business needs, industry, or the unique aspects of each role. With that said, thanks for watching, and until next time.